Hello everyone, welcome to another episode of Courts This Week by LiveLaw. I'm Debojit Das and this is Advocate Ostika Das here with the biggest legal developments. From transparency in top appointments to preventive detention, environmental clearances and even a Netflix title. It's been a packed week in India's courts. So without further ado, let's begin. Our first story this past week started with a question of should the public know when the leader of the opposition disagrees with the appointments to the Central Information Commission. That question reached the Supreme Court this week and the court declined to examine it. Ostika, can you elaborate on this story a little?
A bench led by Chief Justice of India, Suryakant, with Justices Joy Malabakchi and N.V. Anjaria, refused to direct disclosure of the opposition leader's dissent in the CIC selection process. Prashant Bhushan, appearing for RTI activist Anjali Bharadwaj, argued that citizens have a right to know why the opposition dissented. The CIC, for some context, enforces the RTI Act, so transparency in appointing its members, he said, is fundamental. He also pointed out past instances where individuals without substantial RTI experience were appointed as Chief Information Commissioners. Since the selection committee includes the Prime Minister, a union minister and the leader of opposition, the concern was about executive dominance in what should be a neutral body.
And how did the court respond?
The Chief Justice was clear, we will not go into that. Instead of directing disclosure, the court asked the union to file a status report on how many candidates applied and how many were shortlisted. This is consistent with an earlier observation by the Chief Justice of India that disclosing dissent could complicate appointments and that objections can be raised after the appointments are made.
So the appointments stand, but the debate on transparency hasn't been settled yet. Our second story this week is one that has sparked a serious debate within judicial circles. Ostika, what's happened at the Allahabad High Court?
Justice Pankaj Bhatia has formally requested the Chief Justice of the Allahabad High Court not to assign him the bail roster in future.
That's dramatic to say the least. What triggered it?
So just 4 days earlier, the Supreme Court had come down heavily on one of his bail orders in a dowry death case, calling it one of the most shocking and disappointing orders it had encountered in a long time. In that case, the High Court had granted bail to a husband accused in the death of his wife within 3 months of marriage. The post-mortem showed death by strangulation. The Supreme Court said the High Court failed to consider the statutory presumption, the gravity of the offence and other settled bail factors and instead merely recorded the period of incarceration and absence of criminal history.
And the Supreme Court cancelled the bail.
Yes. And this week, in a subsequent order while dealing with another bail plea, this time involving a murder accused, Justice Bhatia of the Allahabad High Court stated that the apex court's remarks had a huge demoralizing and chilling effect on him. He then requested that he not be assigned bail matters going forward.
Has the Supreme Court criticized the Allahabad High Court like this before?
Yes. In fact, last year, another bench led by Justice J.B. Pardiwala had issued a stern direction in another matter, even asking the Chief Justice of Allahabad High Court not to assign criminal matters to a particular judge after flawed reasoning in a separate case.
We've been tracking the Sonam Wangchuk detention case closely. Ostika, what's the latest from the Supreme Court this week?
It's been a tense week inside this courtroom. On February 9th, the Union government told the Supreme Court that there has been no progress in reviewing Wangchuk's preventive detention under the National Security Act. When asked directly whether reconsideration had taken place, Additional Solicitor General K.M. Nataraj responded, no, nothing has been done. The centre maintained that Wangchuk is in a perfectly good condition and receiving the best treatment at AIIMS Jodhpur. Treatment, it said, he would not have received in Ladakh.
But the bench did not seem entirely satisfied, right?
Not at all. The court reiterated concerns about his deteriorating health. Remember, senior advocate Kapil Sibal had earlier sought a specialist medical examination after complaints of stomach pain allegedly linked to contaminated water. A medical report from AIIMS Jodhpur has now been submitted. Justice Varale reminded the union that the court had already suggested reconsidering the detention. And when ASG Nataraj sought more time, Justice Arvind Kumar responded sharply, this is habeas corpus, you can't say that. The urgency of personal liberty was clearly emphasized.
And what happened on February 11th?
The hearing shifted back to the core legal question, which is public order. The centre argued that even if violence did not directly flow from Wangchuk's speeches, the potential of his words to disturb public order in a border-sensitive region justified preventive detention. They relied on precedents like Ashok Kumar versus Delhi administration and Ajay Dikshit versus State of UP, arguing the test is the impact on the tempo of community life. The centre also said Wangchuk attempted to internationalize domestic issues, spoke of referendums and compared Ladakh to Tibet. But the bench appeared skeptical, remarking that the union may be reading too much into his speeches.
So where does this leave the case?
at a crucial crossroads, and the court's tone this week suggests that scrutiny is only getting sharper.
Our fourth story this week is a major environmental law update from the Supreme Court. Ostika, what exactly was being challenged?
Congress leader and Rajya Sabha MP Jairam Ramesh filed a writ petition under Article 32, challenging the grant of ex post facto environmental clearances, approvals given after land has already been acquired or projects have effectively moved forward. Ramesh has repeatedly argued, including in a public statement this January, that such retrospective clearances are bad in law, harmful to public health, and undermine environmental governance. He also flagged that in December 2025, the Union Environment Ministry changed its policy for non-coal mining projects, allowing environmental clearance to be sought even after land acquisition is complete.
So, is this about environmental safeguards just being diluted?
Correct. This is a fait accompli that is often presented, and that was the core question raised. But the Supreme Court did not get into the merits. The bench led by Chief Justice of India, Surya Kant, pointed out that in November last year, a 3-judge bench had already upheld the Union government's office memorandums on retrospective environmental clearances in the Vanashakti review judgment.
So, the court saw this as settled law.
Exactly. And Chief Justice asked, how can a writ petition be maintained against a position the Supreme Court itself has already approved? When counsel said they were also challenging a January 2026 office memorandum, the bench asked, why was that OM issued? The answer? To implement the Vanashakti judgment.
So, was the court suggesting this was indirectly a review petition?
Precisely. The bench made it clear that if a notification merely gives effect to a Supreme Court judgment, challenging it through a fresh writ effectively amounts to seeking a review of that judgment in disguise. And in a sharp remark, the Chief Justice even asked, have you filed this for media publicity? Be ready for exemplary costs. For now, the Supreme Court has firmly declined to reopen the question of ex post facto environmental clearances, leaving the November ruling intact.
Serious allegations of hate speech against Assam Chief Minister Himanta Biswa Sarma have now reached the Supreme Court. Not once, but twice this week. Ostika, what exactly is being alleged here?
So, 2 separate petitions were mentioned before the Supreme Court seeking action against the Chief Minister over allegedly inflammatory speeches targeting Bengali origin Muslims in Assam. In the first, Advocate Nizam Pasha mentioned a plea filed by the Communist Party of India Marxist and Annie Raja of the Communist Party of India seeking registration of an FIR and a court-monitored SIT. That petition lays out a chronology from 2021 to February 2026 alleging repeated calls for social and economic exclusion, including denial of jobs, land, transport, and even voting rights emanating from the sitting Chief Minister. It also refers to a video briefly uploaded on BJP Assam's official X handle, allegedly showing the Chief Minister with a gun using the words point blank shoot and no mercy. That video was later deleted.
So this isn't about a single remark, it's about a sustained pattern.
That's what the petitioners are arguing. And the second petition reinforces that claim. Advocate Rupali Samuel mentioned another plea before the bench led by Chief Justice Surya Kant. This one is filed by Sahitya Academy awardee Dr. Hiren Gohen, former DGP Hare Krishna Deka, editor Paresh Chanda Malakar, and senior advocate Santanu Borthakur. They allege that terms like Mia and Bangladeshi were used as slurs and pejoratives, that calls for boycotts were made, and that during electoral roll revision, references to Mia votes were publicly invoked by the Chief Minister.
Are they also questioning the state's response so far?
Yes. The petitions say that despite complaints, no FIRs have been registered. Relying on precedents like Tehseen Poonawala and Shaheen Abdullah, they argue that once speech crosses into hate speech, registration of FIRs, even suo motu, is mandatory. They also cite alleged offences under the Bharatiya Nyaya Sanhita and the Representation of the People Act, and even claim violation of the constitutional oath under Article 164(3).
And constitutionally speaking, what's at stake here?
The petitioners argue that Articles 14, 15, 19 and 21 cannot become dead letters when inflammatory speech comes from high constitutional office.
Can a Muslim woman end her marriage on her own without her husband's consent? Can her right to divorce depend on his approval? And if he refuses, does that mean she must remain married? For our sixth important story from the past week, that's the question now before the Supreme Court.
Exactly. And the court has appointed senior advocate Shoaib Alam as amicus curiae in an appeal challenging a Kerala High Court judgment that upheld a Muslim woman's right to invoke something called a khula and terminate her marriage without the husband's consent. The Kerala High Court, in a judgment by Justices A. Muhammad Mustaq and C. L. Dias, held that Islamic law recognizes a Muslim woman's right to dissolve her marriage through khula and that her will cannot be made dependent on the will of her husband.
So what exactly did the High Court say?
It was categorical. It said that the right flows from the Quran itself and is not subject to the husband's acceptance. It also laid down conditions. The wife must declare termination, offer to return the dower or material benefits received, and an attempt at reconciliation must precede the declaration. In dismissing a review petition against this judgment, the High Court went further, saying that portraying Muslim women as subordinate to male will reflects hegemonic masculinity. It also clarified that Islamic clergy, without formal legal training, cannot decide questions of law for courts.
And what was argued against this view?
The review petition claimed that a wife must first demand talaq from her husband and, if refused, approach a qazi or court. The High Court rejected that entirely. A major question on marriage and Muslim women's rights is now headed for authoritative clarity at the Supreme Court.
For our seventh story from this past week, we have a couple of updates from the West Bengal Special Intensive Revision matter at the Supreme Court. Questions like, is a missing middle name enough to question your right to vote? And can software decide who gets notice? Ostika, tell us a little more about these updates.
So, a bench of Chief Justice Suryakant, Justice Joymallo Bagchi and Justice N.V. Anjaria made one thing absolutely clear. The SIR process will not be stalled. The Chief Justice said court will not allow any impediment to be created in the completion of the Election Commission's special revision process in any state. And this is significant because the court is not just hearing challenges from West Bengal, but if you remember, also from Bihar, Tamil Nadu, Pondicherry and Kerala.
But concerns were raised inside court, right?
Yes, especially about the software being used. Justice Bagchi flagged that voters are receiving notices over minor name mismatches. For example, omission of Kumar, a common Bengali middle name, or variations like Roy and Rai. He observed that the tools applied in the software appear very restrictive, casting a much wider net than necessary. Even when the Election Commission's Counsel Senior Advocate D.S. Naidu said mapped voters to the 2002 rolls would not face issues, Justice Bagchi responded, questions are asked, sir. Notices are for mapped people. Not only this, but the court also clarified that micro-observers can only assist EROs and AEROs. They cannot take final decisions. So directions may continue to evolve, but the message from the Supreme Court is firm, and that is the SIR will go on.
For our eighth story this week, the Supreme Court has put the Indian Railways under sharp scrutiny. And this time the focus is squarely on safety. Ostika, what exactly was the concern here?
Devajit, the bench of Justices Ehsanuddin Amanullah and R. Mahadevan made a very strong observation. They said nothing is more important than the safety and security of the common man who travels by train and reposes trust in the railways. They were clear enough to mention that the railways is not an organization meant to invest elsewhere while safety infrastructure needs urgent attention.
And this isn't just a broad policy comment. The court is actually looking at specific issues.
Exactly. The court is examining two major areas. First, eliminating unmanned level crossings by building overbridges and underbridges. Second, expanding Kavach, the automated anti-collision system meant to prevent accidents caused by human error. The Chief Commissioner of Railway Safety appeared before the court and said that interlocking level crossing gates would cost less, take less time and make Kavach far more effective once it's rolled out nationwide.
But the court did not seem satisfied with just that explanation.
Not at all. The bench, in fact, flagged concerns about projected timelines stretching till 2042-43 for some safety works. They've now asked their union to file a detailed affidavit disclosing budget allocations over the last 3 years, internal fund distribution and actual expenditure, including figures for 2025-26.
There was also something about ticket insurance, wasn't there?
Yes. The court questioned why insurance is available only for online bookings and not for passengers who buy physical tickets. It reiterated that insurance should extend to all genuine passengers regardless of booking mode.
And finally, this week, the Supreme Court decided that it was important enough for it to step in over, believe it or not, an upcoming Netflix release and a community's claims of denigration because of it. Ostika, what happened with Ghooskhor, Pandat?
Well, the Supreme Court stepped in after objections were raised that the title defames the Brahmin community. A bench of Justices B.V. Nagaratna and Ujjal Bhuya issued notice to the Union of India, the Central Board of Film Certification and Director Neeraj Pandey in a PIL filed by Atul Mishra. But the controversy first reached the courts earlier this week after a writ petition was filed in the Delhi High Court first, opposing the title and the content. The plea alleged that the title amounts to collective defamation and vilification of an entire religious and social community and would cause irreversible harm to the dignity and reputation of acharyas and the Brahmin community at large.
But what about freedom of expression and creative expression?
To that, the court pointed out that it was important to see the freedom of speech under Article 19(1)(a) side by side with its reasonable restrictions. The bench directly questioned the title, asking why should you denigrate a section of society by this kind of title?
So what happens to the release now? Will we see Manoj Bajpayee on screen anytime soon?
Well, that depends. Counsel for the makers told the court that steps are already being taken to change the title. The Supreme Court has directed them to file an affidavit formally confirming the withdrawal of the current name and stating the new one. It made it clear unless a new title is placed on record, the series will not be permitted to release. The matter is listed for further hearing on February 19th. The series starring Manoj Bajpayee, directed by Neeraj Pandey, was slated to stream on Netflix, but for now its release depends on the name placed before the Supreme Court.
And that was your complete legal wrap-up of the week. For deeper reports and real-time courtroom updates, visit livelaw.in and follow us on all our socials to stay updated with everything that is law.